independence in sentencing is critical. You cannot have politicians wading in with their size 12s in the case of individual sentencing decisions. But the sentencing framework is something that I think that the Lord Chancellor should be able to have the ultimate sign-off over. Something must be done. Jury trials are incredibly important. There is a place for them. What I'm proposing is for certain cases, even if they're in the Crown Court, there is the right of the Crown Court judge to say, no, this isn't going to be judge and jury in the Crown Court. This is going to be judge and wingers in the Crown Court. I will never stop thinking about this country. I think it's a wonderful country, and I feel very invested in its success. And I'll always want to play my part insofar as I can to contribute.
This is the Lord Chancellors, where politics meets justice. Brought to you by the University of Law. Alex Chalk-Casey was the last Lord Chancellor and Justice Secretary in the previous Conservative government. He promoted greater use of community penalties, but also measures to ensure the most serious, violent and sexual offenders would serve longer inside. He advocates reforms to trial by jury to help reduce the backlog of cases in the Crown Court, with a new intermediate court consisting of a judge and 2 magistrates to handle some middle-ranking cases. Chalk was MP for Cheltenham from 2015 to 2024. He held several ministerial positions, including Solicitor General for England and Wales, Minister of State for Defence Procurement, and Minister of State for Prisons and Probation, before becoming Lord Chancellor in April 2023. Before politics, Chalk practised as a barrister for some 16 years after being called to the bar in 2001, specialising in serious fraud, counter-terrorism and homicide cases. After losing his parliamentary seat in 2024, he returned to private practice at the bar, but in January this year joined the international law firm Jones Day as a partner in the global disputes practice. I began by asking Alex Chalk about the present state of the criminal justice system. Could I start by asking you about the state of the criminal justice system, which I think is pretty well agreed to be in a crisis state?
I think...
What's your analysis of it?
Yes, I'm afraid that is a fitting description. I did a trial earlier this year, and whilst the fundamentals are in place, I had a fantastic judge. I mean, she was so good.
Who was it? Let's name
Bobby Chima.
Oh, yes,
I had to tell you, Chima Grubb, Mrs.
yes.
Justice Chima Grubb, and she was really genuinely exceptional. And
she did a high-profile sentencing recently.
She did, yeah. She did. She does the terrorism list as well, I think. Yeah. Anyway, but the point is all the components of the criminal trial were really as I remember and as I expected them to be. So there are lots of aspects of it which are fantastic. Our system itself is intrinsically very good, but the pressure and the hangover from COVID is so great that I think it can properly be termed a crisis. And that is felt in the form of cases taking too long to come on. So an alleged rape which takes place today, I think, can only reasonably be expected to be tried in 2028, maybe.
Yes.
I mean, it's completely
that's
unacceptable.
Appalling, is it?
It
unacceptable.
It's unacceptable. And I think it's worth just appreciating the reasons behind all that. I don't know if you want to go into it, but just in a sentence, there is no doubt that COVID had this incredibly scarring impact. And of course, the problems were there before, there's no doubt about that.
I was going to say, I mean, obviously, you as a Conservative, and I don't dispute it for a minute, I think COVID did have a big impact. But of course, there was 14 years of Conservative rule and maybe underfunding.
No, that's true. Well, I mean, I think I made the point from my position as Secretary of State that I would always have wanted more money. The boring factoid that I tell everyone who will listen is that the total annual budget of the Ministry of Justice, which of course deals with prisons, probation, and by the way, over 100 custodial establishments in Britain, so 100 prisons, probation, the entire court service, that's all the buildings, all the judges, all of legal aid, etc. That annual budget, about 14 billion, is spent by the Department for Work and Pensions in 2 weeks.
Yes,
so that just gives you a sense of the scale of difference.
Exactly,
Yep. So there were issues. There's no doubt there were issues. However, on some of these fundamental metrics, which impact the public, namely the number of cases in the Crown Court backlog or caseload. We started in 2010 with about 48,000. That had then dropped in September 2019 to around 39,000, and it's now up to over 70,000. So whilst people can say, well, 14 years, etc., and I have absolutely no doubt that not everything was done right, and people make complaints about sitting days being cut, etc., etc. But there's no doubt, as far as the criminal courts are concerned, right up to the point preceding COVID, actually burglaries had come down and violent crime had come down considerably, and the caseload was down.
Okay, so we've got that on the court side, and we'll come to prisons in a minute. What can be done about it? You've been on record recently as proposing various things, and we know it's all being looked at by Sir Brian Leveson in a review, and I think that will report next month. What do you think the main thing that should be done is? Well,
the first point is to recognise that something must be done, because I've read carefully the views of some of the detractors, and I understand that nobody wants to do anything in principle which impinges upon the right to a fair trial. I certainly don't. I think the jury trial, right to a jury trial, not to a fair. Jury trials are incredibly important. There is a place for them, but it's always worth reflecting that place has always been narrowly circumscribed. So what we're looking at, and what I'm proposing, what Sir Brian is looking at rather than what I'm proposing, is for the eligibility for jury trials to be recalibrated, evolution, not revolution. It's already the case that over 90% of criminal trials are heard in the magistrates' court, and it has been for a long time. My mother was a magistrate, my grandmother was a magistrate. They're incredibly important and fair-minded people. So that's that. What I'm suggesting is that there are some cases which are currently in the Crown Court and taking up that limited capacity. For example, assault on emergency worker, serious, but it's not as serious as a rape or a murder, you may think, that those could conveniently be tried by a different constitution of the Crown Court. And what I'm saying is, even if that goes to the Crown Court, in other words, not in the mags, that should be a judge and two wingers to hear those cases where the maximum sentence is, say, 2 years.
Yes.
Now, the net effect of that is, A, you get through those cases more quickly, because some poor old police officer who has been thumped whilst making an arrest, or an ambulance worker or whatever, it's not right that they should be waiting 2.5, 3 years for the trial when the harm itself was unpleasant, but they shouldn't. It should be much more a matter of somebody. And also, it clogs up the cases for all the other murders and manslaughters.
Of course, it does. So we're talking here about the offences where the defendant has the right to choose at the moment to go to the Crown Court, are we?
Exactly. So-called either way offences. Now, look, you could recalibrate this in all sorts of different ways. You could say some cases which are currently either way, you should make them summary only, or you could say, no, we'll keep them as either way, but certain cases, even if they're in the Crown Court, there is the right of the Crown Court judge to say, no, this isn't going to be judge and jury in the Crown Court. This is going to be judge and wingers in the Crown Court.
So you'd keep a choice, would you, for the defendant?
I personally would. I personally would.
And that's what you proposed, have you?
That's what I've proposed. But I also think it's right that having elected Crown Court trial, there should be more flexibility about what kind of trial that is, because there are certain offences where if you drag them out in this way, it does nothing for victims of crime. And it has a double whammy. First of all, the victim of that specific crime, racially aggravated common assault, for example, feels frustrated and indignant because they don't get their justice within a reasonable period of time. But the double whammy is, of course, somebody awaiting trial on a rape or a murder, or the families awaiting trial, I should say, are waiting longer because everything has been clogged up by these lower level offences.
Now, do you get the feeling that Sir Brian is minded to adopt your proposal?
Sir Brian is an extremely capable fellow who is capable enough not to let me know what he's planning.
Well, you must get a feel for whether he's sympathetic.
I've got a feel that he recognises the scale of the problem. Yeah. He also recognises that doing nothing is itself taking a decision.
Not an option.
And I think he probably does take the view that it's not an option. The point that I've been at pains to stress is that politics is the art of the possible, and so whatever it is he comes up with, there's no point in offering up the moon on a stick if ultimately there is neither the money nor the political will to do it.
This is the next thing. I mean, do you see the current government taking on these proposals? Say it was your proposal.
Well, look, that is exactly the issue. So what I would have gently encouraged Sir Brian, and with some diffidence, I hasten to add, is don't try to boil the ocean. Don't try to do everything, because you could end up with nothing. And if he doesn't land this, in other words, if the government takes one look at it and thinks, hang on a second, we're going to struggle, even with this majority in Parliament, we're going to struggle with this. If he's over-ambitious in his terms,
nothing will happen.
Nothing will happen.
And then
if
what?
it is irrecoverable. I tell you this now.
When you say it's irrecoverable, do you mean the
backlogs?
The
backlogs are irrecoverable.
So what does that mean?
Prison crises are irrecoverable. You will never get this back onto an even keel.
So then what would happen?
Right. So
just taking that worst case scenario.
In very simple terms, what it means is this: is that the current situation in prisons, where you've got a remand population largely made up of pre-trial detention, people awaiting their trial in custody, it's gone from 9,000 up to 17,000. Right? If you have the current status quo, that will never come down, or it won't come down within a reasonable time frame. It won't come down for a generation. So the only way you bring that down is to speed up the throughput through the courts. Mm-hmm. That in turn will free up space in the prisons.
But I'm saying, if this was not adopted, would we be facing mass release of all these prisoners, or what?
Well, what I'm saying is that without this kind of action, the drumbeat or the risk of further release schemes becomes intolerably high.
Yes.
Right. So the government is already in a tight spot. If people have been concentrating,
they've already had to release.
They've already.
And you yourself, I think, released some prisoners.
I was very under end of custody supervised license. I was very candid about the state of the situation we found ourselves in. But I just want to make this point: is that even having done that, right? So they brought in SDS 40. You'll have noticed I didn't criticise them for that, because I think ultimately they didn't have much choice, being blunt. But
by that you mean the release of the short-term
the point I was going to make is that even having taken a painful step, the numbers are already back at 99% or so, and the government has done Operation Safeguard, which is effectively where you're using police prison cells at the cost of about £700 a day or something.
So there's nowhere else really to go.
Precisely. So my point is this: is that without really quite decisive action to increase the throughput, this problem will come back again and again, and the problem will be in the form of further releases, and it will be in the form of unacceptable and potentially even more unacceptable delays in the Crown Court. So something has to happen. But the sweet spot for Sir Brian...
And we'll get miscarriages. We won't get people's crimes pursued.
Well, people will drop out.
Witnesses won't give their testimonies.
Yeah. So the good news is that we're prosecuting more allegations of rape than 2010, and a huge amount of hard work has gone into that. But people are also dropping out of the process, and that's unacceptable. And also we're papering over the cracks to encourage people not to drop out by paying for extremely expensive independent sexual violence advisors who do an important job, but part of their job is please don't drop out.
I think when you were in post, one of the things you were against was any kind of early release for longer term prisoners, the serious ones, rapists, murderers, and other people with serious crimes. You mentioned one earlier. That's probably going to be something, if not rapists and murderers, long-term prisoners are going to be looked at, aren't they, by David Gauke, one of your predecessors? Yes, in his own review of sentencing, I think.
Yeah, well, so it's important just to remember that Sir Brian, of course, is looking at how the court system works, and David Gauke is looking at the length of sentences and so on. Just worth reflecting before we go into the David Gauke point, that the thing that will have the more immediate impact actually on the prison pressures may well be what Sir Brian does, for the reasons that I've indicated, because of this throughput point is so significant for the prison population. However, David Gauke's review is nonetheless extremely important. So to your question about whether he's going to be looking at some of these longer term prisoners, I'm sure he will. I was looking, first of all, at short term prisoners, those who were sentenced to under 12 months, because the data shows that those people who have an immediate custodial sentence, in other words, stand up please Joe Bloggs, down you go, and you're actually serving that sentence, if it's less than 12 months, their chance of reoffending is over 55%. If that sentence, however, is suspended, that's to say it doesn't take immediate effect unless and until they breach one of the terms of the order, then it's about 24%. So I was looking specifically at that, but I suspect, I don't know, that David Gauke will be looking across the piece beyond simply short sentences and looking at longer sentences.
Well, I think
as
he will. I mean, is that something you would support, or would you oppose that?
Well, it depends what he comes up with, doesn't it? It
But
depends what he comes
supposing,
up.
for example, he wants to release a lot of the current long-term prisoners. Let's leave murderers out of it, because that's quite contentious.
Look, I don't want to be evasive, but I think the devil is always in the detail. You have to think very, very carefully, because when you talk about long-term violent offenders, you can't necessarily group in the same way a terrorism offender, a Section 5 terrorism, somebody who's prepared or planned an act of terrorism, as opposed to somebody who's thumped someone in a pub queue because he's had too much to drink. The two are completely different. So I think you have to see you have to think quite carefully about what he's going to look at. The other point I just want to make briefly, if I may, is you're right to exclude the issue of murder, but that is something that the government has itself excluded. And that means that this sentencing review is pregnant with a problem. I tell you why, because part of the issue that judges are grappling with is the fact there's been so much inflation in respect of sentencing murder. It used to be, for a standard murder, when I started my career, if you can ever call a murder standard, but you know what I mean for the purposes of this podcast, you'd get a 15-year minimum term. You wouldn't necessarily be released at the end of that, but then the Ben Kinsella case came along with knife crime. That was 25 years. Anything to do with firearms is 30 years. But the net effect is that has dragged up sentencing for manslaughter or for GBH or ABH. And if you don't reform the murder sentencing, then there's a risk that you still retain that incoherence within the overall sentencing.
His review has been kind of stymied from the start.
I think it was a missed opportunity to look at this in the round, okay? Because we have to ask ourselves a question as a nation in terms of what we think is fair, but also what we think is affordable and deliverable.
Yes.
What should be the sentence for murder in circumstances where someone brings a knife to the scene? Now, at the moment, we have a perverse situation where if the murder takes place in the street with a knife brought to the scene, that's a 25-year starting point. But if the murder takes place indoors with a knife that is taken from the kitchen cutlery drawer, it's 15 years. And so imagine how the feeling of those, the parents in the respect of the Gould case and the DV case, where their poor children were slain by these terrible purported boyfriends in their own home, and yet they sit there and go, hang on, the sentencing regime was less than if it had happened in the street. So anyway, so my point is there is lack of coherence, and I think they should have considered that in the round.
Indeed, and without looking at murder, really, the whole thing is a little bit flawed or weakened, hold below the waterline.
No, I wouldn't go that far. I would say it's a missed opportunity. David is a great former Lord Chancellor. He will look at this carefully, but I think it was a missed opportunity to bring coherence to the whole sentencing regime.
And could I just want to check one thing I should have mentioned earlier? Am I right in thinking you actually brought in legislation requiring rapists and maybe other serious sexual offenders to serve their full prison term?
No, so what happened was, in the sentencing bill, that was proposed, that they should serve their full term in custody. In other words, if you get 10 years, you serve every day of those 10 years. And those were some of the tougher measures that we were keen to see in place. And at the same time, I wanted to see some more, how can I put it, some slightly less robust measures in respect of short-term offenders. So that was what was in the sentencing bill. And also there was further stuff in there about the minimum term for murders involving serious sexual or sadistic behaviour.
Right.
But that all fell.
But that was all to do with making it clear to the public that if someone was jailed for 12 years, they would serve 12 years.
That's exactly right, yeah.
That was the point of it.
Yeah.
Okay, I'd just like to move on now a little bit to your personal career. We're sitting here in Jones Day, to where you've moved as a partner in corporate dispute.
It's global disputes. So the work we do here, it's sometimes called crisis management. So if, for example, in a corporate, someone or they'd walked off with a load of money, misappropriated money, then this firm would be able to go out and freeze any assets and to seize them potentially, or internal investigations. So corporates might come to us and say, listen, there's a bit of trouble at mill. Could you come along and do an external investigation? So we do that, and I'm on a couple of those at the moment.
How are you finding it? It's very, very different from being in chambers or in politics.
But it is what it isn't. So just yesterday I was doing an interview of somebody who was alleged to have been up to no good. And you definitely draw on some of the experience that you've had at the bar. And I enjoyed it. It's all about preparation. It's about marshalling material, asking questions in the right way, being meticulous about follow-up. So I think there's a certain amount of carryover.
You won't be standing up in court in the way you were. You won't
not in the way that I was in January of this year in this dreadful murder case. Yeah.
Are you missing that?
I do miss that a bit. There's no doubt I miss that a bit. The case I did in January was unbelievably harrowing. It was a case involving the killing of a 15-year-old girl, Elianne Andam, outside the Whitgift shopping centre in Croydon on a morning in September 2023. It was a truly dreadful case. 17-year-old boy killed this girl. And in fact, there's been a lot of talk in the papers about Adolescence, which you may have seen on TV. And the suggestion was that there might be in some way based upon this case. I don't know about that, but it was incredibly harrowing. And people say, do you enjoy the work that you do? And there is a professional satisfaction, but it was incredibly difficult and upsetting. And I've done so many cases in my life. And the truth is, you harden your heart because you have a job to do and you have to be professional and you have to be rigorous and unemotional about it. And there are really only two cases which I found profoundly affecting. And this was one of them. And I think it was just meeting with the parents of the victim every day or almost every day and understanding how they'd been so profoundly affected. Yeah, and they wrote me a beautiful letter just earlier this week, actually, about their experience of the criminal justice system and how, it's a private letter, so I won't go into it, but it was really lovely to receive.
What happened to the perpetrator in that case?
23 years. He was convicted, and that's a minimum term. Bear in mind, he was 17 at the time of the offence, 18 at the time of his conviction. So he has a life sentence with a minimum of 23 years. But of course, as you know and your listeners will know, that doesn't mean that he's released automatically at the end of those 23 years. That's the minimum period before which he can apply to the parole board.
And how was it going back to the bar after your stint in politics?
Well, some of it is reassuringly familiar. So it's examination sheet, cross-examination, speeches, all that kind of stuff. But there are definitely changes. And funny enough, the thing that's most striking is, as always, is technology. So quite a lot of the technology has moved on in terms of how cases are presented and collated. So that took a bit of getting used to. But I had a fantastic junior, and he made sure that I was pretty up to speed on it by the time we got to trial. So, really professionally satisfying, but quite harrowing. Yes.
You mentioned Adolescence, the series. There's been a lot of talk about, a lot of debate. Did you watch it yourself?
Well, I'm halfway through it. I watch it with my wife. Yes. And I understood why some people were drawing a parallel between what had happened in the case that I did, the Centimou case, and Adolescence. I've got young children, similar sort of age, so I think a lot of people have been impacted by it. I didn't personally see the parallels between the case that I prosecuted and it, but nonetheless, it's thought-provoking. I think the mere fact that it started a conversation is probably a positive thing.
Why did you go into law? You had law in the family. You mentioned your mother was a magistrate.
Yeah. Well, I remember in the summer of my second year at university, I went off and decided to get as much work experience and as many different things as I possibly could. And I thought then that I wanted to go into the Foreign Office. I knew that the idea of kind of public service was really important to me. And that's kind of what I had my heart set on, aged 19, 20. And then I did a couple of mini pupilages. And I remember just going into court. I went into Snaresborough Crown Court. And I listened and I watched it. And I thought, this is it. This is what I want to do. This is what.
When were you doing that? At what age was that? After you?
No, that was age 20s. That was the summer of my second year.
Yes. And you thought, right, this is it.
And I thought, this is it. This is what I want to do. And I felt profoundly grateful that I'd had that opportunity to really crystallise my thoughts. I did also spend some time in the Foreign Office, but again, although it's that's a great career, I spent too much time dealing with visas for Brits who'd either got lost or got drunk or eaten them or something, or whatever it was. And I thought, you know what, I'm going to the bar. I'm not going to be in the visa section dealing with this.
Did you read law?
No, I read modern history.
Oh, you read modern history.
I read modern history, which I adored, and it's a lifelong passion, history. And then I came out and I did the GDL, as it's now known, or the CP as it was then.
The course you have to take to transfer if you've done a non-law degree and then you want to go to law.
And if any aspiring lawyers are listening, blimey, it's a tough course. I mean, don't be put off, but go into it.
The GDL.
Yeah, the GDL. Yeah, it's really hard. There's just so much that is compressed into that 9 months.
You're doing what some people have taken 3 years to do.
Yeah, it was very, very demanding. But I remember that year extremely well. I decided, no, it was going to be no fun. It was just head down, study.
Where did you go to school?
Where did I go to school? I went to school, Winchester College.
Okay. Yeah. Right, so then it was to Oxford.
Oxford, yeah.
Yes. Then to the bar, which is a fairly standard route. Why did you then switch horses, if you like, and go to politics?
Well, I mean, I'd always, as I mentioned about the Foreign Office stuff, I really believe in public service, and I'd always kind of had an ambition, not so much to go into politics, but I suppose to put myself amongst the problems of the country and try and play my poor part in their solution. And then my hometown of Cheltenham came up. I remember where I was off to see my sister, who was living in Africa at the time, where her husband's a wildlife vet. And Cheltenham came up, and I thought, I'm going to fill out. I'm going to go for it. And I filled in the application form, didn't think too much of it, actually. And then I was actually, funny enough, I was prosecuting a trial down at Canterbury Crown Court, which was an election fraud of all cases. And the message came through that, I'd been asked for an interview to Cheltenham, and I raced up there, and then second interview on a Sunday night, as I recall, and then I was the candidate. That was 2013.
Did you give up the bar at that point?
No, I couldn't.
No,
I couldn't. And funny enough, actually, this was a source of some slight tension between me and CCHQ, because I was very, very upfront with my association. I said, listen, if you select me, I'd love to be selected, but you have to understand I've got a career, and my career is in London. I can't be here every day of the week. I have a family to support, and that's just the way it's going to be. And then I remember being hauled in by CCHQ saying, but you're not there every day. I said, yeah, I know, but I told you, I can't be. I've got a job. Either you want professionals or you don't.
Well, you went into politics and you held a number of portfolios, prisons, legal aid, Solicitor General, and then on to being Lord Chancellor, / Justice Secretary.
With a small hiatus of being the Minister for Defence Procurement as well.
Thank you, indeed. So how did you find the role of Lord Chancellor? Do you think it's a role that works? It was reformed, as we know, 20 years ago. Does it work in its current form? You have to deal with the judges, hold the balance of power between the executive and the judiciary.
I think the truth is, in peacetime, it works very well. In wartime, it's a bit more difficult. What do I mean by that? What I mean is that if everything is humming along quite nicely and you haven't got massive prison population pressures, then I actually think that the setup works as well as many others. The difficulty comes when the system is under intense strain, particularly when it comes to prisons. And the reason for that is simple, that by disconnecting the Home Office from the MOJ, you can have a situation where a Home Secretary's ego is writing cheques that the Lord Chancellor can't cash. In other words, the Home Secretary is saying, I want to burnish my credentials as a tough on crime Home Secretary. So I am going to create a whole series of offences for people who should be banged up.
Sure.
And although there is, of course, Cabinet collective responsibility, the MOJ is expected to sign off or indeed to block a right round which creates an offence which will generate additional demand. The realities of politics are the Lord Chancellor, as the junior partner in that relationship, will come under a lot of pressure to say, to wave these things through. And so that fundamental disconnect of the demand being created upstream by a department that isn't responsible for supply creates a problem. Now, as I say, in peacetime,
that's okay.
It's a part of a wrinkle of the Constitution.
On that point, I mean, do you think it should be separate again? Do you think that prisons should be back with the Home Office?
Well, I certainly think it needs to be looked at, because whilst there is a proper concern about the Home Office being too unwieldy, I do think it's worth having a conversation about whether there are other elements of the Home Office that could conveniently be hived off. I don't know what necessarily those would be, to create space for prisons to be reunited. And that should be. I don't have a finalised view on that, but I do know that the current situation is not without its problems. The only other thing to remember, however, is this: that the Lord Chancellor benefits from having a significant department. In other words, if the prisons go and it's left with dealing with courts legal aid and courts, that's quite light. And of course, if you're sitting, it's a weak position. If you're sitting there in cabinet and without being sort of petty about it, but it has its own symbolism. You're on the front row of the cabinet photo, so to speak. It's sort of the fifth office of state. Then I think it does need to have a bit of budget heft. And so...
Particularly as it's not the power it used to be. It used to
Correct.
be number 2 in the cabinet, and now you're saying it's number 5.
Exactly. So I do think that there is a point about that. So look, all these things have to be considered from time to time. The former Lord Chief Justice Ian Burnett raised this issue. I think he was right to raise it. I think in slow time, it's worth having a discussion. That the central point, however, is that at a time of crisis, at a time of wartime, if you like, that's to say, metaphorically speaking, I think the system does come under quite a lot of pressure.
Did you find that yourself? Did you have any particular tensions with the judiciary?
Well, hang on.
Or indeed cabinet colleagues?
Yeah, I mean, I think there's always a bit of creative tension between the Home Secretary and the Lord Chancellor. I think for the reasons that I've indicated, that is always lurking in the background. So that is one aspect of it. The point, though, you made about with the judiciary, I didn't particularly have a difficulty with the judiciary because I had grown up in my professional career appearing in front of them, and overall, in the overwhelming majority of cases, I think we have extremely high quality judges. And one of the things that was so nice as Lord Chancellors travelling abroad is the extent to which that reputation is global. And it's partly because, by the way, these High Court judges, who rumour has it have got a certain amount to be getting on with, still seem to find time to go around the world to do advocacy training or to support international rules-based law.
They're good ambassadors for our system.
It's incredible soft power.
Yes.
Incredible soft power for Britain. And we in Britain also have such a poor understanding of the extent to which our global reach is underpinned by our strength in this area.
Yes. And when you say, talking about tensions, difficulties, time of war, how do you think it's working at the moment between the Lady Chief Justice and Shabana Mahmood, the current Justice Secretary?
Well, look, I'm not privy to those conversations. I don't know, and I hear a little bit. I hear a bit on the grapevine, don't I? I hear a bit on the grapevine, but I don't think it particularly helps for me to weigh in on that. I think I am not unsympathetic to the points that Shabana Mahmood made in respect of some of the issues she's had to confront. I'm thinking in particular in respect of the Sentencing Council, right? Because the Sentencing Council, just for the avoidance of doubt and to put it on the record, do extremely important work. There is no doubt. When I started my career, there was a risk of the sentence in Maidstone Crown Court being different to the sentence in Newcastle Crown Court.
So they've improved consistency.
The consistency and coherence means that if you're sitting there in the cells at the Old Bailey, you can provide really good advice to your client about what he or she is likely to get. So they do fantastically important work. There's no doubt about that.
So just so that people know, perhaps you'd like to summarise the current dispute.
All right, so the current dispute has been in respect of these guidelines. So the Sentencing Council hand out these guidelines, and it could be how you should go about sentencing GBH or violent offences, how you sentence murder, rape, and so on. So there are these guidelines which are produced. But there's also a guideline which is about when the bench, or indeed the judge, the sentencing tribunal, should be ordering what's known as a pre-sentence report. Now, pre-sentence reports provided by probation, and effectively they are to look at the circumstances surrounding the offence and the offender, and what potential non-custodial penalty could be provided. Now, although a judge receiving a PSR may say, well, look, this is all very interesting, but I'm sorry, the offending was so serious that nothing less than a custodial sentence will do, and that's exactly where you're going. Nonetheless, there is an impression that is given that if a PSR is ordered, then at least a non-custodial sentence is in play, right? Yeah. And so, of course, the whole argument was whether this should be, in effect, mandatory unless and until the judge departed from the sentencing guideline, but it should be indicated in circumstances where someone comes from certain ethnic groups.
Certain groups of people. Well, was that sensible to do that? It looks so bad. That's the trouble.
Well, this is it. Look, I mean, I do think the time has come to recalibrate how the Sentencing Council works, because independence and unaccountability are two sides of the same coin. Of course, independence in sentencing is critical. You cannot have politicians wading in with their size 12s in the case of individual sentencing decisions, and that is axiomatic. No. But the sentencing framework is something that I think that the Lord Chancellor should be able to have the ultimate sign-off over, and that's what I would favour.
And do you think they've gone a bit too far?
Well, look, I'll just give you one example. Yes. I'm not going to get involved in this specific row, but I tell you the one thing that was concerning me, which I would have revisited if I'd remained Lord Chancellor, was this business about credit for a guilty plea. So the Sentencing Council has decided that at what's known as a PTPH, so that is the principal hearing in the Crown Court, so it would have been through the Magistrates' Court for a first appearance, might have had a preliminary hearing, gets to the PTPH in the Crown Court, that if a person pleads guilty at that stage, he or she cannot get a full third discount, can only get a maximum of 25%. Now, what I wanted to see was that the judge having the discretion to say, listen, I've looked at the facts of this, I've listened to what prosecution counsel said, I've listened to what defence counsel said, and actually I think it would be fair on the facts of this case for this guy to get a full third.
So leave that to judicial discretion.
I think so. No, but my point is that the sentencing guideline said thou shalt not give a third.
Quite.
Now my feeling was, hang on, I'm the Lord Chancellor here.
Yes.
Right?
Well,
and I actually think it should be a third. But then when I went back to the Sentencing Council, effectively there was very much across our arms. Well, this is the way we're going to do it.
Oh, really?
And I thought that the balance was
who
wrong.
Who was the chairman at the time you were?
Well, I'm not going to bring out individuals because I think they have a tough enough job as it is. But I do think that the time is right to recalibrate that relationship, and that is not in any way to decry or undermine the work of the Sentencing Council.
To give the Justice Secretary rather more oversight, or to reduce the power of the Sentencing Council?
No,
reduce its discretion.
The Sentencing Council should continue to do everything as it is, but there should be a lock. That's to say, a Lord Chancellor's lock. So if a veto, there should be a right of veto.
Okay,
yeah, I think that's right.
Well, you're really agreeing with Shabana Mahmood. All she wanted to do was to say, well, hang on a minute, I don't like this.
Correct, and I do think it leaves the Lord Chancellor in an unacceptable position if he or she is not able to stop these sorts of guidelines coming into force. Now, to be clear, and in fairness to the Sentencing Council, I think what they would say is, oh yes, well, hang on, we do write and consult the Lord Chancellor. And that's true, but it's not the same as providing ultimate power to the Lord Chancellor as a democratically elected representative.
Oh, well, that's very interesting. Thank you. But as far as the actual issue is concerned, and as far as these actual equality guidelines or whatever they called them is concerned, did you support those?
Well, so what I said is that the guideline that came to me for consideration, which was whether, in fact, somebody who came from a deprived socioeconomic background should be treated more leniently by the courts. I said that was patronising and ridiculous because some of the most upstanding, decent, law-abiding, excellent members of society are people who've had a difficult start in life, and it's fundamentally patronising to assume that because you've had a difficult start, you're incapable of obeying the law, which I thought was the implicit message.
Absolutely.
So I did push back.
You're talking about these ones now.
I did push back on those guidelines, and that was the guideline that I saw, and I thought that was the wrong thing. But again, I didn't have power to block it.
I'd like to ask you about the state of the Conservative Party. Are you still actively engaged with it in any way? Are you advising or keeping tabs on your former colleagues?
Do you know what? I am a citizen, and it's a total joy. It's a total joy, and I'm a Conservative supporter. I will remain a Conservative supporter, I suspect, for the rest of my life. But
what are your predictions for the state of the Conservative Party? I mean, how are they doing?
We gloriously returned to office at the next election.
I don't know.
I don't know. I don't know. I think it's really a very complex political landscape at the moment. And one thing, this is not a new observation, so forgive me for saying something unoriginal, but it does have the advantage of being true, is that affiliations are far more fluid now than they ever used to be, and things can change in a heartbeat. And we're also seeing that natural political fluidity is being overlaid by global instability. In other words, there are so many of it. Look at, for example, Reform had a lot of wind in its sails, and yet I think people are now thinking, well, hold on a second. Some of these very complimentary remarks about Vladimir Putin are suddenly not looking terribly clever. Some of these very complimentary remarks about what might be happening stateside don't necessarily go down particularly well in Britain. And I think given that level of fluidity and instability, it's very hard to predict the future.
Do you think Kemi Badenoch can see off Nigel Farage?
I do think she can, actually. I really genuinely do think she can, because I think, shall I tell you what the most precious commodity in politics is? It is courage. And she's brave as boots, and she speaks very directly. And I'll just make one other observation as well, is that on what I think is a fundamental issue for our country, which is about how we remain competitive so that contemporaries of mine or younger people don't all disappear off to Dubai and to Australia. Part of the reason is because Britain is feeling so overtaxed at the moment that people are disappearing. And I think she speaks with such clarity on this point. And without being too land of hope and glory about it, Britain is a great, great country. We have fantastic culture. We have fantastic institutions, the universities we were talking about, the rule of law, wonderful climate, the English language, a great time zone. For people to be disappearing off to Dubai with no discourtesy to Dubai does not hold a candle to Britain. And so I'm saying that if we can just recalibrate and make people feel that they've got a stake in society here, we will get the brightest and the best hanging around or indeed coming here. So to the point, Kemi makes those arguments well, and I think she can earn the trust of the British people. But nothing is certain because it's so fluid, as I indicated.
It's not. I mean, you got into, not trouble, but there was some controversy at one point when you supported Elianne Andam over his...
Oh, gosh, do you remember that? Oh, yeah.
Just for the sake of people watching or listening, I think he said that asylum seekers who didn't like their accommodation here could just... I can't use the word, F off back to their countries.
Well, to be clear, I didn't endorse that. What I said is not the language that I described it as salty language, and that.
But you supported this.
And then I heard Michael Gove using the expression salty language. I thought, that's it. I've arrived.
Yeah.
I've arrived. I've really.
And you accepted.
Yeah.
But
I didn't.
You did support him on that point.
There's a serious point here, which is that Lee Anderson, not unreasonably, was tapping into a sense of real indignation about the British people, that we are a fair-minded country, but you can have, and we are also compassionate, but you can have a warm heart, but also want to have a secure front door. And I think he felt frustrated about that. I feel frustrated about it. And I'm somebody who believes in the rule of law. I'm somebody who believes we shouldn't be unilaterally pulling out of the European Convention.
I was going to ask you.
And yet, it is totally wrong that you have a situation where people can be effectively arriving illegally on our shores in a way that offends against our sense of basic justice.
Exactly.
Why is it right that people should be able to jump the queue and take advantage of our good nature?
Of course.
So Lee Anderson was expressing himself in ways that no doubt, I wouldn't use, you wouldn't use, but he was making a reasonable
You're not
point.
tempted to reform, is really what I'm asking.
I'm not going to reform. However, shall I tell you one thing which I think is worth reflecting, is that although I'm not tempted to reform, there is an area where I think those on the right of centre will naturally coalesce. And that is when Jeremy Hunt was talking about Britain becoming a sort of Singapore on Thames. I think there is a powerful sense that if we want to have a sense of generational justice, in other words, that your children and my children are not bequeathed a toxic inheritance, but instead Britain is a going concern, we are going to have to do something like Singapore on Thames. And I think the point is the right of centre can agree on that. And I think that could be quite a unifying principle.
There's a story in the papers today, there's a proposal that's been around, digital ID cards for immigrants. Do you support that?
In principle, yes. I don't have a difficulty with it. I think the arguments that David Davis was making about ID cards back several years ago, decades ago now, I think are no longer extant. And I also think that it's perfectly appropriate to look at how we could be reconsidering a lot of the international apparatus of law when it comes to how immigration works in Britain.
But not the European Convention.
Well, we talked about the Convention. So the reason why I think pulling out of the Convention unilaterally is a bad idea. I mean, there are several reasons, but the first one is it will not deliver what people might think it will deliver. So the thing about these totemic issues, whether it's a referendum or whatever, people say, aha, all my problems will be fixed if you just put that out of the way. Once that's gone, it'll be motherhood and apple pie, everything will be sorted. And of course, life isn't like that. And anybody who'd spent 5 minutes listening to what the Supreme Court said in the Rwanda case, where they were at pains to say, the President of the Supreme Court said, by the way, those of you who think this is all about Article 3 of the Convention, no. It's the ICCPR, International Convention on ICCPR, and then, of course, the Refugee Convention.
That was the main one, wasn't it? The Refugee Convention.
Yeah.
But perhaps all these treaties need to be looked at when it comes to our freedom.
So that's my point. You should look at this in the round. And Britain has extraordinary expertise and, again, a point poorly understood, enormous influence in this area. So just one little brief anecdote. When I was Lord Chancellor, I went to Strasbourg, and your listeners may be interested to know that all the member states of the European Convention have their own embassy in Strasbourg. Quite amazing. Anyway, you go along there. So I was there, and when they heard that the British Lord Chancellor turned up, I think every other member state representative ambassador turned up to listen. And the reason was because we have outsized influence there, in large part because of the calibre of our judiciary, the quality of the jurisprudence that comes out of these courts, the consideration that is given to these convention rights, which is extremely scholarly and very, very impressive. Plus, I'm bound to say, the quality of the advocates who also appear in Strasbourg. So the net effect is we have we enjoy a lot of respect in Strasbourg. If we in Britain were to say, well, look, the law is a living instrument. We think it does need to be revisited in light of current circumstances, and we shall do so coolly and calmly and respectfully with other nations. I think it very likely that the Dutch would want to take part in that, and the Austrians and the Swedes, and all these countries.
We could take a lead on it.
We could take a lead, and I think we could build, to coin a phrase, a coalition of the willing. So I think it's completely correct that we should do this.
Yeah.
And whereas those people who, and I understand politics is primary colours, it's stop, start, black, white, go, leave, whatever. But actually it's more complicated than that. But we can be muscular and ambitious in terms of looking at reform, whilst not binning the whole international rules-based order, which we have played such an important part in promoting over the years.
Alex Chancellor, your own future. You're not leaving politics for good, surely, after such an impassioned answer.
Well, I will never, at the risk of sounding pious and sanctimonious, I will never stop thinking about this country. I think it's a wonderful country, and I feel very invested in its success. And my heart thrills when I see us going up the rankings for something, and my spirits sink when we go down. So I will always be interested, and I'll always want to play my part insofar as I can to contribute.
Well,
but probably not in Parliament. Probably not in Parliament.
I don't not think immediately, so. But possibly in the future.
I genuinely, I know this is not evasive. I no more have plans to go into Parliament than I do to cycle to Istanbul. But I've always wanted to cycle to Istanbul.
This podcast was brought to you by the University of Law. Subscribe now to make sure you don't miss the next episode.